Welcome to Steve and Tamara Explain Corp's Law, the podcast where two entirely self-appointed experts pretend to know more than they actually know about companies, directors, shareholders, and the occasional legal catastrophe.
This is the place where we take the cases, legislation, and big corporate theory ideas you're meant to understand, and then immediately make them sound much less serious.
So whether you're a law student desperately trying to survive corporations law, someone who wants to learn about companies and the laws that govern them, or just someone who enjoys listening to us laugh at our own jokes, you're in the right place.
Each episode, we dive into real cases, which we sometimes mislabel, but almost always correct afterwards, and the weird and wonderful corners of Australian corporate law. And sometimes we wander into adjacent territory because none of you can stop us.
So grab a coffee, open your textbook, and let's get into today's episode of Steve and Tamara Explain Corp's Law. Hi everyone, I'm Steve Carabas. I'm an Associate Professor at Monash Law School and the Deputy Director of the Centre for Commercial Law and Regulatory Studies. And I am joined today.
Hi, I'm Tamara Wilkinson. I'm a lecturer at Monash University. And we would love to welcome you to this episode of Steve and Tamara Explain Corp's Law.
So this is our first official episode. So we're going to talk about a case today that builds on from another case that you might have considered already, Salomon's case. Today we're going to speak about Lee and Lee's air farming, and Tamara's going to talk to us a little bit about that. But before we start, I thought that it would be really useful to just kind of familiarise ourselves with why this case exists, really. And I mean, it builds on, as I said, from Salomon's case, where you had a bootmaker who incorporated his business. And the question that the courts were looking at there was, is Mr. Salomon separate to his company, which was also called Salomon?
Yeah.
And the courts in Salomon decided that you can have a person who owns virtually all of the shares of a company, and the law will treat them as separate to that company. And it's one of the reasons that we have this concept of a separate legal entity. And another thing that is relevant when looking at separate legal entity is the related concept of limited liability. So it's because we have separate legal entity as a concept that we can have a limited liability concept. And that just means really that if the company is in trouble, the creditors of the company cannot go after the assets of the shareholders, with some exceptions, that we call piercing the veil.
Yeah, and also the directors are protected.
Are protected as well.
Provided they don't do anything terrible.
And also in terms of insolvent trading, they may be liable for breaching the insolvent trading provisions as well.
Yeah.
And we have the Salomon case. It's an old case, and I think we start to really think about what are the ramifications of this case, what would follow on from the case. And Lee's air farming is one of the earlier cases that looked at what does it really mean to have this separate legal entity concept. And so I thought that we would ask you to begin, what happened in this case?
Yeah, so it's a really interesting and slightly sad case.
Sad, yeah.
My question for you is, do you know where Lee and Lee's air farming actually happened, where the facts actually occurred?
Oh, no, I don't. I maybe I should, but I don't.
Well, I didn't until I started preparing for today. New Zealand. It was initially a New Zealand case.
Oh, right, there you go. Yeah. I really should have known that.
And it was actually appealed to the Privy Council in the UK.
Of course.
And then impacted, obviously, New Zealand law, UK law, Australian law, and Indian law.
Right, there you go, yes. So it was a Privy Council case. There you go.
Privy Council decision, that was appealed up. So what happened in Lee and Lee's air farming was that Mr. Lee was an air farmer.
Funnily enough,
enough. He had a business called Lee's Air Farming, and what he did was spray crops from a plane. So he formed Lee's Air Farming to run the business, and he was the director of the business, of the company, and he was not the sole shareholder, but I think maybe there were about 3,000 shares and he held 2,999.
So if I can recall, it was, it's virtually all just like in Salomon, and I think maybe his lawyer owned another, but I may be confusing the facts there.
His lawyer or his wife.
Or his wife. No, I'm not sure. We should look into that.
He was virtually the sole shareholder.
He was also an employee.
Well, that was the controversial part of it. So there was no official employment contract, but Lee was the only person involved in the business, and he was appointed by a company resolution, by resolution of himself, because he was the only director, as the chief pilot of the company. So he was paid to fly the plane and spray the crops.
Okay.
So the sad part of the case, of course, is that he died in a plane crash while working. And his widow, Mrs. Lee, tried to claim workers' compensation because he died in the course
on the job.
Yeah, on the job, exactly. Yeah. And the workers' comp organisation, union, insurer.
Those in charge of distributing workers' compensation at the time.
Exactly. In 1960, which is when this case was decided, said he wasn't an employee. He was the director of the company and, the by far the majority shareholder of the company. He wasn't a worker of the company. And they didn't say, their lawyers said, you can't be both the master and the servant.
Right. Yes.
So eventually...
It's really interesting because it's still, even at that time, still debating the exact status of a corporation and how separate it can be. Exactly. Like, we still haven't resolved that even by the time of this case.
Exactly right. And I think the complicating factor is that, as we talked about, there was no employment contract. If there had been an employment contract, I think that Mrs. Lee would have had an easier time making out her proposition, which was that Lee clearly was an employee of Lee's Air Farming.
Yeah.
But because there was no explicit employment contract, it was then more difficult. And as you said, there's still that uncertainty around what does a separate legal entity really mean. Yeah. So at a certain point, this case made its way to the Privy Council in the UK. The court decided that actually Lee was an employee, and they based that on a couple of factors. He had the resolution appointing him as the chief pilot.
Okay, that's pretty good.
It was pretty good.
Pretty good evidence. Yeah.
And even though that resolution was made by him as the sole director, we know from Salomon that doesn't matter.
Yes. So you could see the real ramifications there of Salomon's case, right?
Exactly right. Yeah. Exactly right. They also based their decision on the fact that, in addition to this resolution, he was paid a salary. So, like an employee would be paid a salary, Lee was paid a salary to fly the plane and dust the crops. Yeah, the outcome was really a strengthening of the Salomon principle of separate legal entity. It was found that he was an employee of the company. It didn't matter that he also was the company.
The company itself, a director, a shareholder, everything, all of that. He could still be this employee of the company.
Exactly right. So he was employee, majority shareholder, and director. And the court said that, there really isn't another way to interpret the separate legal entity doctrine such that wouldn't
it's really kind of extensive implications of this case, right? And I think something that we've been grappling with ever since. Before we started talking, we were discussing other contexts in which this could exist, whether it's someone committing a crime against the company, whether that is possible because the company is a separate legal person. So even if you're the sole shareholder director, you may be able to commit a crime against the company. So serious kind of implications there. And also, I think it kind of sets the scene for an ongoing debate that we've been having in corporations law ever since, and society. How do we look at the reality behind what we call the veil? Piercing the veil or lifting the veil? Because in some instances, there may be certain abuses where we do want to hold the people behind the veil liable. And so I think that this case really sets that scene quite well, because you really establish that it's no matter what your other capacity, the company can be separate. Yeah.
One of the reasons I love this case, unlike Salomon, where I personally have never found Salomon that sympathetic, because essentially he was getting paid out ahead of the other creditors. Lee and Lee's Air Farming is one of those cases where you're like...
It's a really sad case. Sad case.
And you want his wife to have gotten the workers' compensation.
Yeah, certainly, right. Although I think Salomon was also... we've had other discussions about Salomon, and it's not as rosy a picture for Salomon either, considering his background and everything like that. It's also quite a sad story, but, not as sad, I guess, if we're grading different levels of sadness of these cases.
Corporations law case sadness.
Yeah, that's a separate podcast.
We'll have to do more research.
Yes, we'll need to look into that more. So I think, is there anything else? I mean, I think that pretty much sums up Lee and Lee's air farming.
I think that is a pretty good précis of Lee and Lee.
Yeah, if I were to think of where this has gotten us up to at this point with Lee and Lee's air farming, we've really established that it is completely separate, and from that point on, we start to ask that question, when is it not separate?
Yes, that becomes far more the issue that we have to get around.
Yeah, but although I do think that an interesting point for all of this analysis of Lee and Lee's and Salomon's case is that it wasn't always widely accepted. I think we can question this. So if we go back to the debates regarding Salomon's case and then these cases that followed on, a lot of people were unhappy with it. We just take it for granted now that that's how this works. But you can actually question whether we should have companies being completely separate. There are other ideas, like, is a small private company that has one person, should that be separate? Are there other ways that we can protect people rather than just this kind of one-size-fits-all approach of companies being completely separate? So there's a lot of debate still ongoing in terms of this topic.
Do you remember, and this is not a question that I have the answer to, unlike the previous one, do you remember what year Salomon was decided?
No, not off the top of my head. I can't remember the year, but it was in the 1800s, late 1800s, but I can't remember the exact year.
Because Lee and Lee's air farming was 1960.
Yeah.
So that really does illustrate exactly what you said. We take it for granted now that there's a separate legal entity doctrine, but that was, 60 plus years of legal uncertainty.
Yeah. And I mean, you're also transporting all of this into different jurisdictions, right? Like you were saying, Lee and Lee's farming was in New Zealand, in Australia, UK, and all of these jurisdictions have slightly different approaches as to how they treat the separate legal entity concept. So when you're looking at these cases, it's relevant and important to consider the time that this was happening, and also the jurisdiction. And in particular, when you're reading a case like Lee and Lee's farming, you're also considering issues of employment law, insurance law. And for our purposes, when we're looking at this, we're actually just really looking at the broader concept of, is this a separate legal entity? And no need for our purposes to get confused with the broader issues of, is this how employment law would work these days, or will insurance have a different outcome in the modern context? So just something to keep in mind when you're reading these kind of cases.